How does a $12 million pet trust get gutted in court, while a $4.7 million pet trust survives a court challenge without losing a dime? Same state, same statute, even the same year. The only difference was in the drafting. Here's the multi-million-dollar problem. Leona Helmsley left $12 million for Trouble, her Maltese, and a New York court reduced it to $2 million because the funding couldn't be justified against documented care costs. But when an executor tried the same argument the same year to reduce Lenoir Abel's $4.7 million pet trust for two cats named Polka Dot and Ginny, the New York court refused, ruling that granting the petition would improperly rewrite the decedent's express intent. The difference? One drafting decision that exposed a tension no court has fully resolved. How much is too much for a pet trust, and what evidence decides? In episode 109, Pet Trusts Gone Wrong, part 2 of 2, we compare how evidence, documentation, and specificity determined opposite financial outcomes under the same statute, expose the structural conflict of interest that many pet trust documents ignore, and reveal the critical monitoring and identification provisions every pet trust needs. Join us to see how it litigated.
When fortunes collide with courtrooms, wealth managers, financial advisors, accountants, fiduciaries, and lawyers need real answers. Welcome to Wealth Litigated, where Professor Kelly Lise Murray, JD, lawyer, legal scholar, and retired Vanderbilt Law faculty, analyzes actual courtroom wins and losses in asset protection to deliver actionable insights that optimize your client's wealth outcomes. From explosive family feuds over fortunes to sophisticated financial fraud, each week we explore what worked to protect wealth and what exactly went wrong so you get it right. And now, here's your host, Professor Kelly Lise Murray.
I'm Kelly Lise Murray, and this is Wealth Litigated, delivering all the drama of true crime without the blood. We break down actual court cases that impact your professional practice and your client's wealth outcomes. Let's gavel in. Pet trusts are also popular with high net worth clients, including billionaires, and a recurring litigated issue for these pet trusts is overfunding, which means pet trusts are important for wealth protection and pet protection. Two high net worth pet trusts both faced overfunding challenges in court. One was reduced by 83%. The other didn't lose a dime. What's the difference? In New York, in 2007, two high net worth women died within months of each other. Each left millions to their pets in testamentary trusts. Each had no living children. Each carefully drafted instructions for the pet's care. Both trusts faced overfunding challenges. The Abel's trust faced a challenge from the co-executor. Here's what happened with the Trouble Pet Trust. The first caretaker declined. This was Leona Helmsley's brother, and for security reasons, with the dog facing over 20 kidnapping and death threats, that makes sense. But Leona Helmsley, famously known as the Queen of Mean, used the pet trust to disinherit two of her 4 grandchildren. Her son, their father, had predeceased her. 2 grandchildren inherited $5 million each if they visited their father's grave at least annually. The other 2 grandchildren were disinherited by the pet trust. Trouble's annual budget, the documentation showed less than $12 million given the life expectancy. The expenses were documented as follows. Caretaker, $60,000 a year. 24/7 security, $100,000 a year. Grooming, $8,000 a year. Veterinary care, $2,500 to $18,000 a year. Food, $1,200 a year. Miscellaneous, $3,000 a year. These are the documented expenses that the court allowed in the Troubled Trust Court Challenge, and it totaled $190,000 a year. Based on that, the court drastically reduced the Trouble Pet Trust. Here were some additional planning failures in the Helmsley Pet Trust planning. Contingency failure. The designated caretaker refused. There was no backup. Publicity risks. Publicizing the inheritance led to over 20 kidnapping and death threats for the dog. legal scrutiny, this pet trust disinherited 2 of 4 grandchildren, inviting legal challenges, which is what happened here. There was no documentation to justify $12 million for this one dog. And then the cost overrun, security costs consumed a significant portion of the trust funds themselves. In the Helmsley troubled pet trust, the court's decision on funding was based on the following. $12 million was excessive for the care of one dog, reduced the pet trust by 83%, went from $12 million to $2 million. An affidavit indicated $2 million covers the care at the highest standards for 10 plus years, and a veterinarian predicted that this dog's remaining lifespan was approximately 3 to 5 years. Fast forward, the dog lived 3 years from Leona Helmsley's death. She died in 2007. Trouble, the Maltese, died in 2010. From 2007 to 2010, Trouble lived in Florida, and the caretaker was the manager of one of the Helmsley hotels. And Trouble's final resting place, not where Leona Helmsley wanted it. In contrast, the Copeland Pet Trust litigation was initiated by the co-executor of a $4.7 million pet trust for 2 cats. Even though the grantor died in 2007, this case was litigated into 2014 when the co-executor sought to sell the grantor's house where the 2 cats were residing. A takeaway from the Copeland case: when intent is clearly documented and trust terms are well defined, courts do show significant deference, and that's what occurred in the Copeland case itself. Key facts: the 2 cats were named Polka Dot and Ginny, ages 7 and 9 when the grantor died in 2007. The caretaker was the grantor's housekeeper, who was to remain in the grantor's house caring for the cats, salary $40,000 a year plus a $5,000 annual bonus. The co-executor of the trust petitioned to reduce the trust in order to sell the house. He argued that the house was expensive to maintain and required significant repairs. 33 named animal charities. Unlike other trusts we've looked at, this pet trust was specific about the named remainder beneficiaries after all cats passed away. The executor sought to reduce the pet trust. The entire estate, $4.7 million, was left in testamentary trust for the cats, which means the trust did not fund until her death. Cats and the housekeeper to remain in the house throughout the animal's lifetime. The executor petitioned to reduce the trust to $440,000, so from $4 million to $440,000 in order to sell the house and redirect the remaining funds to the 33 named charities immediately. Why the court refused the executor's request to reduce this pet trust. First, granting this request was rewriting the decedent's express intent. She had painstakingly planned the care for her cats. She specified and documented the costs of their care. She was specific about the purpose of the trust, which coincided with the New York statute. The cats' lifespans and future care costs were included. And even though she could have chosen a less expensive option, the fact that she chose and documented the more expensive option confirmed grantor's express intent. This case had the opposite result from the grantor's death in the same year as Leona Helmsley. In Helmsley, the trust was overfunded relative to the animal's documented needs. In this trust, the express intent included extravagant expenses that the grantor approved. Side-by-side comparison, the amount $12 million for one dog reduced to $2 million over 3 years. The Copeland Trust, $4 million for 2 cats. Both grantors died in 2007. Helmsley's trust was reduced by 83%. The Copeland Trust was upheld in full. Helmsley Trust simply overfunded relative to the documented care costs and the lifespan of the dog. Cats have a longer lifespan, and reduction would contradict express intent of the grantor in the Copeland case. The care instructions were general from Leona Helmsley, the highest standard. By contrast, in the Copeland case, they were specific. This house, this housekeeper, this salary for the housekeeper, this bonus for the housekeeper. Helmsley's remainder was her and her husband's charitable foundation. And in the Copeland case, it was 33 named animal charities. Both functioned as they were intended, unlike the Jablonski case. The permission is overfunding. How much is too much? There is no bright line. In New York, there's a specific statute, and it gives the court discretion. And that's what occurred with these two 2007 pet trusts. In the Copeland case, it permitted reduction but didn't require it. The statute talks about if the trust substantially exceeds the amount required. 41 states have adopted the UTC-based statutes. 11 states use the substantially exceeds standard. There is still no clear dollar ceiling. Changing gears based on information provided by Professor Jerry Beyer on his website, Structuring Pet Trusts. First, the remainder beneficiary problem. This is a structural conflict of interest many trust documents ignore. When the person caring for your pet benefits from its death, the conflict is self-evident. Naming the caretaker or trustee as the remainder beneficiary creates a direct financial incentive to hasten the pet's death. So this is the single most common structural conflict in pet trust drafting. By contrast, naming an unrelated charity, ideally one focused on the same species, as the remainder beneficiary. So the Copeland Pet Trust structure succeeded with 33 named animal charities as the remainder of the $4 million trust. The housekeeper, the caretaker, only received her salary and bonus, no remainder interest. She was actually incentivized to keep those cats alive. The conflict checklist flagged these combinations. When the caretaker is the trustee, is the remainder beneficiary, you have the triple conflict, the highest risk. Don't do that. Caretaker as the remainder beneficiary, a direct incentive to hasten the death or at least not preserve the life of the pet. The trustee as the remainder beneficiary, no independent check on distributions. How does the trustee verify care of the pet? Without a monitoring provision, there is no enforcement mechanism. Required monitoring provisions, what every pet trust needs: regular inspection rights, mandatory documentation. The caregiver must submit receipts and expense records for reimbursement. Annual veterinary health verification. Vet certifies the animal is alive and receiving appropriate care. The reporting periods specify how often the caregiver must report to the trustee. Without inspection rights in the trust document, the trustee has no legal basis to intervene if the caretaker neglects the animal. The enforcer role, UTC Section 408, an appointed enforcer has legal standing to sue the trustee on the animal's behalf. Best practice, separate the role of trustee, caregiver, and enforcer, 3 separate roles to avoid the conflict of interest. And because one person in all 3 roles eliminates all checks. Prove it. Prove it is your pet. Animal identification provisions. For high-value trusts, fraud and substitution risk is real. Animal identification, what every trust should include. Microchip number, ISO standard 15-digit chip for dogs and cats. Veterinary records identifying the specific animal. For high-value trusts over $500,000, DNA profile retained by the trustee. Photographs with date taken. Physical description, species, breed, sex, coloring, and distinguishing marks. Annual veterinary verification confirmation, confirming the identified animal is alive and in the caregiver's care. Why this matters for the Helmsley $2 million trust and the Copeland $4.6 million trust? The financial incentive to substitute the animal is significant. Those caretakers were only paid so long as the animals remained alive. That caretaker is incentivized to substitute if the pet dies. This provision also protects the trustee. Documentation prevents disputes about whether the correct animal is being maintained by the trust. Critical takeaways for pet trusts gone wrong. What wealth protection and pet protection includes. Unintended consequences of pet trusts, risks that are often overlooked. The publicity risk. Publicized inheritances for pets can attract unwanted attention and create significant security threats for the pet and the caretaker. High-profile cases have led to kidnapping and death threats, necessitating increased security. Administrative burden. Managing a pet trust involves complex tasks like ensuring specialized care, finding guardians, and overseeing funds, which can consume significant assets, leaving less for the pet's actual needs. And then family resentment, including disinheriting heirs with the pet trust itself. That's not recommended. Perceived disinheritance of human family members can increase resentment, potentially leading to legal challenges and costly litigation that undermines the pet trust intent. Red flags for undue influence, warning signs when reviewing estate plans for pets. Vulnerable client profile, elderly or isolated client, especially if estranged from family. Pet trust created shortly after a new caretaker or employee becomes involved. Caretaker benefits disproportionately. Caretaker named as trustee or remainder beneficiary. Conflict of interest financially. Significant deviation from past plans. Noticeable and dramatic changes compared to previous estate plans. Limited independent advice. Client has minimal contact with independent legal or financial advisors. Financing motivated by spite. Funding amounts seem driven by personal animosity rather than the pet's actual welfare. Key considerations for pet planning. Proactive engagement. Initiate conversations about pet care planning early. Personalized financials. Use actual client spending data, not generic averages. Attorney Laura Martin confirmed in her article that clients often decline to complete the homework assigned to actually calculate costs for their pet. These generalized estimations may not hold up in court. Inflation adjusted projections, model costs for 10 years, 15 years, and 20-year horizons. Caregiver identification, designate primary and backup caretakers for the pet and get all of those individuals or organizations to approve it before the trust is signed. Confidentiality, advise discretion regarding specific trust amounts allocated for pet care. Crucial checklist for trust officers, verify the pet status, confirm the pet is alive before accepting trusteeship. Document expenses, meticulously record all care-related expenses. Understanding uneconomic trust threshold. Be aware of the jurisdiction's threshold for an uneconomic trust that can be canceled when it falls below that $100,000 threshold. Monitor trust assets. Track trust assets against the statutory minimum requirements. Understand trust termination triggers and remainder provisions. Pet trusts, essential drafting checklists. Pet predeceasing the owner. This is Jablonski. Always include a contingency plan for situations where the pet passes away before the owner. Charitable remainders. Clearly name specific charitable organizations as beneficiaries for any remaining trust assets. Also a Jablonski error. Residuary clauses. Avoid drafting circular or looping clauses when defining the disposition of residual estate assets. The trifecta of Jablonski. Acceleration clauses. Draft clauses that accelerate the distribution of trust assets explicitly and unambiguously, or you will end up back in state trial court just like Jablonski. Define intended use. Broadly define the intended use of the trust funds to provide flexibility for the pet's care. Document funding reasoning. Record the rationale and justification behind the amounts chosen to fund the trust. Key takeaways from Helmsley versus Copeland, the side-by-side 2007 pet trusts. That same unanswered question, same state, same year, same statute, opposite results. $12 million pet trust reduced to $2 million, $4.7 million pet trust upheld. Courts have not drawn a clear upper limit on pet trust funding, but keep in mind the critical risk is the underfunded pet trust, not necessarily the overfunded pet trust. Further reading, there's a lot. Be sure to check the description for additional resources. Thank you for joining us. Stay tuned for a preview of our next episode. The best friend is trustee of a dentist's $750,000 life insurance policy. And for 16 years, the system worked. The insurer mailed the premium notice to the friend as trustee. The friend called the wife who deposited money into the trust's bank account. The friend then paid the premium on behalf of the trust from that bank account. Every time for 16 years. Until the friend moved 2 months before the next premium was due. The friend filed mail forwarding with the post office, but never updated his address with the insurance company, never told the dentist, and never noticed that for the first time in 16 years, the dentist's life insurance premium didn't get paid. 2 months after the friend moved, the dentist's life insurance lapsed for non-payment. No one noticed that either, including the insured dentist. 5 months later, the dentist died. And instead of paying his widow $750,000 in life insurance, she got nothing. A federal court sided with the insurer who refused to pay. But it gets worse. 3 days after the dentist died, the friend as trustee called the life insurance company. He never told them the insured had already died. He convinced them to reinstate the life insurance policy as a one-time exception. The friend paid the back premiums. The friend got written confirmation. But when the insurer found out that the insured had died before the reinstatement, they voided the life insurance policy again. When the widow found out, she sued everyone. The life insurance company, the friend as trustee. The friend trustee's best defense? He blamed the widow for contributory negligence because she never put money into the trust bank account for 2 payment cycles. She never asked why no one was calling about premiums. She never noticed 6 months of silence. The court held that argument, contributory negligence, can go to a jury. In episode 110, Life Insurance Trust That Lost $750,000, Friend Trustee Blamed the Widow, we examine how naming a friend as trustee instead of a professional led to the total loss of a $750,000 life insurance policy. Explore the recorded phone call that turned a tragic mistake into potential trustee fraud, and analyze the court's ruling on who was responsible, including whether the widow's own inaction cost her the claim. Join us to see how it litigated.
This is Wealth Litigated, where the real courtroom battles we analyze today are your roadmap to stronger asset protection and better wealth outcomes. Follow us on your favorite podcast platform or subscribe on YouTube so you never miss a weekly episode. Questions or cases? Visit wealthlitigated.com/questions. This show is for informational and educational purposes only and does not constitute legal, tax, or financial advice. No attorney-client relationship is formed. Consult a qualified professional for advice specific to your situation and jurisdiction. Wealth Litigated is now adjourned.